Good afternoon, everybody. My name is Mirah Ranchod. I'm a legal practitioner practicing at Erasmus Ranchod and Associates, and we're situated in the heart of the CBD, Cape Town, South Africa. Today, I'm going to speak a little bit about the socio-economic impact of COVID-19 with a bit of focus on sequestrations and liquidations. So before the world was struck by the corona COVID-19 virus, most economies were either very sluggish or perhaps even in recession. Unemployment was at an all-time high. South Africa was no different, with its unemployment rate around the 30% mark, according to Stats SA. The unemployment rate has been a troubling matter for several years now. The South African growth rate was projected around 3% about a year or so ago, and that projection has been revised downwards several times since the initial projection. The South African situation is exacerbated by the global agencies downgrading us to junk status. So what does junk status mean? The consequences of being downgraded to junk status is that many of the sovereign funds are precluded in terms of their rules and protocols from investing in South Africa. That means existing investment opportunities, investments have to be divested, repatriated. Investments have to be realized at the time that it's not opportune to do so. Apart from the downward pressure on the values, there's also the exchange rate, which we have to consider. And the impact of the COVID-19 on exchange rate for us South Africans have seen the cost of a single US dollar ballooning to around 19 Rand, a British pound about 23 Rand now, and the euro at 20 Rand. This makes the cost of imported goods more expensive than it already was. Luckily, the global price of oil has collapsed. Otherwise, this would also be prohibitive. In addition to this, government's interest bill grows and grows day by day. So it ultimately means that the cost of borrowing increases as the COVID-19 encroaches more and more and impacts our country more and more. South Africa has been in lockdown since the 24th of March 2020. The lockdown is likely to continue for several months, with intermittent relaxations coming into play from time to time, and this is going to depend on how the country responds to the measures that government has introduced in order to curb the effect of the COVID-19 coronavirus on the health of its citizens. The introduction of the lockdown has no doubt had a devastating effect on our economy. In fact, all economies around the world. The political discourse in India, a very complex and diverse society where the ruling party has won for the second, also is centered around a sluggish economy like us and very high rate of employment. So India has once projected a growth rate of 7 to 8%, but according to global experts, has also been regularly revised downwards even before the virus took the world by storm. So the direct consequence of a failing economy is loss of jobs and further unemployment. Most working class people live from day to day, hand to mouth, especially in countries like South Africa and India. Very few people can afford to stay at home, let alone unemployed for a period of 5 weeks, as in the case in South Africa. The USA, for example, let's look at the other side of the strongest country economically. On the fact or level, he was going to the country's got of unemployment. President Trump introduced massive tax cuts to boost the economy. It worked even though the greatest benefit accrued to the rich and the wealthy, and they hardly needed it. But by all accounts, the US economy was doing very well until the coronavirus struck the USA. On the basis of a booming economy and record levels of unemployment, Trump was virtually assured of regaining election in November. And even though he was recently impeached by Congress, it really didn't impact his election campaign. But however, things have changed. Its citizens are looking at his inept handling of the COVID-19 virus, and pollsters believe that he might not even win this year's elections. Anyway, turning to a different point, when a country's economy prospers, it's to the direct benefit of its citizens. Most people have work, they earn, they spend their money, and consumption is what drives an economy ultimately. Generally, working classes are slow to save, not because they don't want to, but the cost of the daily needs are so high. There's no surplus to save. So during booming economies, most sectors are thriving. Factories produce, people consume, and people are generally happy with life. During the good times, the working classes spend their money, they acquire all things imaginable for a good and decent life, and this means especially their own homes. It's a growing asset, it adds to one's dignity and self-respect, it promotes family structures and values. So developers build homes, banks are ready lenders to qualifying buyers whose credentials are determined by their employment record and income. When one acquires a house, one needs furniture, so factories are manufacturing furniture and sale prospers. Most people cannot afford to pay their houses or their furniture in cash, so they ultimately borrow from the bank to finance this. Banks agree to lend because the applicant has a job with a steady income, which can support the loan. And cars are bought in the much same manner. So this is a general position when a country's economy expands. The opposite must be true when the economy contracts. As the demand for goods peters out, the working class begin to lose their jobs. The unfortunate tragedy about this is that the most vulnerable are the first victims, and the most vulnerable are the ones with the most debt. With this being said, they are faced with payments and no income, or very little income. So creditors step in to claim payment of amounts due to them. Very soon, matters escalate and things become out of control. Debtor is burdened with legal costs, blacklisted as a bad debtor, and this ultimately shuts off all possibility of further credit. All put together, it brings immense hardship on the poorer classes. Families start to disintegrate and social ills set in, all because of the shortage of money. Loss of jobs often translates into loss of dignity, And there's the old saying of what is a man if he cannot provide for his family? Or I would say, personally, in today's world, what is a woman if she cannot provide for her own family? So, in order to soften the blow, most financial institutions have agreed to grant debtors a moratorium on payments of the installments. But this is not for an indefinite period. So, in South Africa, most major banks have agreed to put a moratorium on payments for at least 3 months or a 3-month grace period. However, the problem becomes more complex because interest continues to mount. So this means that the debt becomes larger. So the debt, and if the debtor remains unemployed and is likely to find any employment soon, in light of the current situation, you can imagine the effects for the debtor with credit or loans that are growing day by day. The South African government has introduced stimulus packages to assist the weak and vulnerable. Philanthropists in South Africa has made huge contributions. The South African Reserve Bank has cut interest rates in order to assist the economy. But this is not enough. It's like putting a Band-Aid on somebody with a heart disease. It's not going to help in the bigger scheme of things. In South Africa, the situation is further complicated by the fact that we have stringent labor laws. You can hire very easily, but you can't fire without long, expensive, and arduous legal processes. So employers only employ when absolutely necessary because of the onerous labor laws. The global position has exploded exponentially due to the coronavirus. Almost the entire world is in lockdown. For example, India went into lockdown on 4 hours' notice. People were taken by surprise. The poorest of the poor were left with absolutely nothing. Migrant workers took to the road back to their villages without any food or money. Some even committed suicide. In South Africa, we were given 4 days' notice of the lockdown. It enabled people to prepare somewhat for the initial 3 weeks of the lockdown. But my question is, whether it's 4 days or 4 hours, did it really matter? Because the overwhelming majority of people did not have the resources to cover the first 3 initial weeks of lockdown. And that is the truth of it. So all businesses, except those rendering essential services, as they were defined in the regulations, were allowed to continue to trade. The rest of us, and the majority of businesses, overnight had no income. Yet the expenses remained. Rentals continued to accrue. As is with smaller businesses, there isn't much capital or reserves. And the economic setback or challenges during this time has been grave on these small businesses. With tenants not being able to pay rentals, landlords were faced with challenges too. They also have expenses and capital commitments of their own. They will have perhaps mortgage bonds, rates, securities, etc. Unless landlords have spare cash lying around to turn to keep going during this time, and even that would dry up at some point in time. So they are very much in the same boat as the rest of the businesses. So most shopping centers around the country are owned by real estate investment trusts. They're known as REIT. Many pensioners are either invested in REITs or cash deposits with banks. This provides a safe and secure monthly income. But pensioners are also faced with hard times now. Because of the reduction of the interest rates, the interest that they earn has become less. And with rates, they have issues and huge troubles collecting rental from tenants. And this creates another nightmare for an elderly person whose income is dependent on the rates. So this is when the real trouble starts for those who are financing their lives through credit. The bank forecloses and demands settlement of their outstanding loans. The same principle that applied to the worker who lost his job, who is unable to pay his car, furniture, or mortgage in settlement, applies to the business, applies to the ordinary debtor out there and to businesses. Many businesses then end up filing for bankruptcy, either voluntary or compulsory, at the instance of a creditor because of the inability to pay the creditors. The law of insolvency is mainly informed by the following pieces of legislation. 1, the Insolvency Act 24 of 1936 as amended. And secondly, the Old and New Companies Act 61 of 1973 and 71 of 2008. So insolvency is often referred to as bankruptcy. So the ordinary person in the street doesn't say John is insolvent, they say John is bankrupt. So generally, what I'm saying is the law of insolvency is potentially quite complex and it covers juristic and non-juristic entities. So in the interest of time, I'm going to limit myself to the individual and highlight certain important and critical issues covering this. But it's also necessary to mention that the Insolvency Act also applies to juristic entities. So what does it mean to be under sequestration? Sequestration is the act of removing, separating, or seizing anything from the possession of the owner under the process of the law for the benefit of a creditor or the state. Insolvency or bankruptcy has far-reaching consequences. It affects an individual's status. A person who has been declared insolvent or bankrupt has no longer any contractual capacity. Section 8 of the Insolvency Act lists a number of acts of insolvency on which grounds the creditor may apply for the sequestration of the debtor when the debtor's assets are insufficient or not sufficient to satisfy all claims. According to Section 8, a debtor commits an act of insolvency when it commits the following 8 grounds. 1, if he leaves the Republic or being out of the Republic remains absent therefrom or departs from his dwelling or otherwise absents himself with the intent of doing so to evade or delay payment of his debts. The second ground, if a court has given judgment against him and he fails upon the demand of an officer whose duty it is to execute the judgment, to satisfy it, or to indicate to that officer disposable property sufficient to satisfy it, or if it appears from the return made by that officer that he has not found sufficient disposable property to satisfy the judgment. Ground 3, if he makes or attempts to make any disposition of any of his property which has or would have had the effect of prejudicing his creditors or of preferring one creditor above another. The fourth ground, if he removes or attempts to remove any of his property with the intent to prejudice his creditors or prefer one creditor above another. The next ground, if he makes or offered to make an arrangement with any of his creditors for releasing him wholly or partially from his debts. The next ground, if after having published a notice of surrender of his estate, which has not yet lapsed or has been withdrawn, he makes any disposition of any of his property which has or would have had the effect of prejudicing his creditors, or preferring one creditor above another, or lodges a statement which is incorrect or incomplete in any material respect, or fails to apply for the acceptance of the surrender of his estate on the date mentioned in the aforesaid notice as the date on which such application is to be made. The following ground, if he gives notice in writing to any of his creditors that he is unable to pay any of his debt. And the last ground, if, being a trader, he gives notice in the Government Gazette in terms of voidable sale of business by transferring in terms of a contract any business belonging to him or to the goodwill of such business, or goods or property forming part thereof, except in the ordinary course of that business, or for securing the payment of debt, and is thereafter unable to pay all his debts. So those were the grounds or the acts of insolvency. Once a person has committed one or more of the above mentioned acts of insolvency, any one of those grounds or more, the person's creditors with a claim in excess of 100 Rand may apply to court to have the debtor declared insolvent or bankrupt. An application for sequestration is brought in the High Court by a creditor who has a liquidated claim for 100 Rand or more against the debtor. It means the creditor needs to engage an attorney and often an advocate as well in order to prosecute the claim in the High Court. This is a costly affair, no doubt. So not only does a creditor run the risk of losing its claim, either in full or in part, but it also exposes itself to legal costs. The creditor, through his attorney, needs to put up a bond of security in the sum of 30,000 Rand to cover the legal costs in the event that the sequestration is later discharged. The same applies to the liquidation of companies. The important difference between a liquidated claim and an unliquidated claim is that a liquidated claim is one which can be easily calculated as a matter of arithmetic or has been agreed to by the debtor. An unliquidated claim is one whose value cannot be determined without reference to the hearing of evidence. So a common example of an unliquidated claim is damages caused to someone's vehicle during a motor vehicle accident, or perhaps defamation. There is also a provision in the Insolvency Act which permits a debtor to surrender his estate as insolvent. It's quite a cumbersome exercise. So it involves the debtor preparing a comprehensive statement of his affairs, which will include all his assets, all his liabilities, and an explanation as to why he ran into financial difficulties. And lastly, why would it be to the advantage of creditors that he be sequestrated? The proposed surrender must be advertised in the local press where the debtor is domiciled and the Government Gazette. Notice must also be given to all creditors. Very few debtors utilize this process. under the Insolvency Act because it's complex and it's expensive. So people take the shortcut. The shortcut is they ask a friendly creditor to apply for a sequestration order based on a written acknowledgement of debt of their inability to pay. So this is Section 8G of the Insolvency Act. It is quite common. The law of insolvency also applies to juristic entities such as close corporations and companies. However, there are additional provisions in the Companies Act. So one interesting provision is that the company is deemed unable to pay its debts after receiving a written demand for payment of an outstanding claim where the company fails to settle or compound the debt within 21 days of receiving that written demand. The new Companies Act also introduced a provision which requires companies to either apply for business rescue or liquidation the minute the directors become aware that the company is in financial distress or in fact insolvent. A classic example of this is the recent application by Edcon. They are the owners of Edgar's, who applied for business rescue. Failure to do so is a criminal offense, and directors can be held personally liable for the debt incurred whilst the company was trading in insolvent circumstances. And you may reference Section 22 and Section 77 of the Companies Act 2008. The advantage of business rescue or liquidation is that it suspends all litigation against the debtor. Legal costs are no further incurred to the prejudice of the debtor. There is also the concept of commercial insolvency. This means that a company is unable to pay its debts in the ordinary course of business, even though its assets exceeds its liabilities. So in common language, we say that a company is experiencing cash flow challenges. There is a significant different additional legal requirement between the sequestration of an individual's estate and the liquidation of a company. And that in the former, the applicant creditor must show an advantage to creditors. So the individual has to show that there is an advantage to creditors for him to be sequestrated. The advantage can include the right to interrogate the insolvent and to search for assets on which grounds may be believed to have been secreted away to the prejudice of the debtor's creditors. The trustee has wide-ranging powers to enforce these provisions. Persons believed to be in possession of the debtor's assets or who may have acquired the assets under questionable circumstances can be interrogated before the master of the High Court or the magistrate in whose area the insolvent is domiciled. There are similar provisions in the companies for companies. However, the liquidator needs to obtain permission from either the master, and if the master of the High Court refuses, then the court to conduct such an inquiry. When someone is declared an insolvent, the master of the High Court appoints a trustee to that individual's estate. The trustee then takes control of the person's insolvent assets and sells it either by way of public auction or under certain circumstances by private treaty, and then distributes the proceeds after the deduction of all costs to the insolvent creditors in the legal order of preference. Where the proceeds of all the insolvent's assets are not sufficient to settle the trustees and other sequestration costs, Those creditors with proved claims against the insolvent are then required to contribute towards the costs proportionate to the value of their claims. One must therefore be careful and make a proper assessment. A proper assessment is in terms of the insolvent's assets and the realizable value before embarking on a sequestration application. It could very well turn out to be throwing good money after bad. Where the debtor is in such poor financial state that he does not have money to live or an income to live for his daily needs, he may apply to the trustee for a modest living amount or allowance, which the trustee can prove with the permission of the master. There is also a strict process whereby a creditor has to prove its claim against the insolvent. This must be done within a specific time or specific period and on a prescribed claim form under oath. If no claims are proved against the insolvent, the sequestration order will then be set aside and the creditor who brought the application in the first place will be liable for the costs. Trustees or liquidators are rewarded by receiving a percentage of the value of assets realized. It therefore follows that trustees will be reluctant to take up appointments where there will be little or no reward because the amount of time and work invested in an estate where the value of the assets realized are very little compared to where it is feasible is the same amount of work. It's also important to note that there is a statutory fee payable to the Master of the High Court. Employees have a considerable amount of say when it comes to the liquidation of businesses. Employees' rights, in terms of the Labour Relations Act, are secured. When a business is placed under liquidation or sequestration, the court will order the relevant court papers also to be served on the workers or employees so that they are able to do what is necessary to protect their rights. Similarly, the papers are also required to be served on the South African Revenue Services, known as SARS, to enable it to be aware of the sequestration or liquidation and claim any taxes that might be due or outstanding. An insolvent's incapacities endure until his rehabilitation. The Insolvency Act makes provision for when an insolvent may apply for his rehabilitation. There are different time frames which are influenced by factors such as the size of the dividend paid to the concurrent creditors, whether the insolvent was convicted of any offense relating to his insolvency, when the liquidation and distribution was confirmed by the master, and so forth. Insolvents are automatically rehabilitated by the effluxion of a period of 10 years from the date of sequestration, unless application is made by an interested party, usually an aggrieved creditor, or the trustee on good reasons shown to prevent such rehabilitation. A company once liquidated cannot be rehabilitated, as in the case with an individual. A company can, however, be discharged from liquidation via a scheme arrangement, which requires the approval of a certain percentage of each class of creditor to support it, as well as its shareholders, its owners. This is referred to as a scheme arrangement. Many people don't utilize this enough, and I have to encourage it on a personal level. I think that it's something to consider in today's time. The scheme must be sanctioned by the court, who must also grant permission for the meetings of creditors and shareholders to be convened to consider the offer of compromise. If the court is of the view that it's not worthy of consideration for whatever reason, it can decline to grant such an order. So, in essence, the coronavirus has had a devastating effect on the world. In the USA, more than 30 million people became unemployed within a few weeks. The British Prime Minister almost lost his life, and President Trump made light of it. And his own political career hangs in a balance. More than 60,000 Americans have died, and the number grows day by day. Many Americans are agitating to go back to work because they have no money to live. Major corporations have gone bust. Here at home in South Africa, the South African Airways is about to fold, leaving 7,000 employees without any work. Edcon, the owners of Edcon, has gone into business rescue. About 17,500 permanent employees are having concerns about their employment. Not to mention the 5,000 casual employees that they have. Edcon also occupies 10% of the retail space in major shopping centers around the country. Landlords will be concerned about who will be replacing this rental income for them because they will be sitting with empty spaces. The leisure industry is on its knees. Most hotels are either completely shut or operating with skeleton staff. Bed and breakfasts are suffering too. These are mainly owner-operated ventures, but the impact of the daily existence and income has come to an halt. Restaurants, bars, places of entertainment are shut. Major sports events have either been postponed or cancelled. Airlines have stopped flying. Major long-standing established airlines are also filing for bankruptcy. Air Mauritius for one, Comair. Tourism, as we once knew it, is no longer. All of these industries employ thousands of employees, and now most of them sit without an income. When businesses are on its knees, government collects less taxes. This ultimately means that there are less and fewer money available to provide social welfare for the poor and the marginalized. The undeniable fact is that this virus has wreaked havoc. Nature has demonstrated its power. Man is without an answer. And if and when we find a cure, which is likely to take a year, the socio-economic damage would have been so pervasive and so far-reaching that it is questionable if we will ever be able to fully recover. One thing is certain, that life as we know it will never be the same again. I would like to say thank you for tuning in. If you have any questions, you are most welcome to email me on the different platforms or on my email address, mirah@eralaw.co.za. Thank you. Stay safe and stay positive.